Entering into a contract is a common part of doing business in Oklahoma. But what happens when you need to cancel a business contract? Whether the deal no longer makes sense, the other party failed to perform, or circumstances have changed. Canceling a contract is not always simple. Oklahoma contract law does provide ways to cancel or rescind a business contract, but only under certain conditions. Understanding your legal rights and responsibilities is essential before walking away from any agreement. General rule: contracts are binding. Under Oklahoma law, a signed business contract is legally enforceable if it includes an offer acceptance, consideration, something of value exchanged, mutual intent to be bound, legal purpose once formed. Contracts are binding, and canceling without a legal basis could expose you to breach of contract liability. That means the other party could sue you for damages, such as lost profits or costs they incurred in reliance on your agreement. However, certain legal grounds do allow you to cancel or rescind a contract. 1. Mutual agreement to cancel. The simplest way to cancel a business contract is through a contract termination agreement, where both parties agree in writing to walk away from the deal without penalties. Even if the original contract doesn't have a cancellation clause, parties can always modify or cancel a contract by mutual consent, as long as both sides agree. 2. Breach of contract by the other party. If the other party fails to perform as promised, whether through delay, poor performance, or non-performance, you may have the right to terminate the contract and seek damages. Common examples include a vendor failing to deliver products on time, a contractor performing work far below agreed-upon standards. In Oklahoma, a material breach of the agreement gives you the right to cancel and sue for breach of contract. 3. Contract includes a termination clause. Many well-drafted business contracts include a termination clause that spells out how either party can cancel the agreement, how much notice is required, whether termination triggers any fees, refunds, or final obligations. If your contract includes this clause, follow its procedures closely to avoid a wrongful termination claim. 4. Fraud, misrepresentation, or duress. If you entered into a contract because the other party lied, concealed key facts, or pressured you, you may be able to cancel the agreement under Oklahoma's contract rescission laws. Examples of fraudulent or coerced contracts include falsely inflating a business's revenue during a sale, hiding legal liabilities before signing a partnership agreement, threatening someone into signing. In these cases, you may have grounds for rescission and damages. 5. Impossibility or frustration of purpose. If it becomes impossible to perform the contract due to unforeseeable circumstances, such as natural disasters, death, or major legal changes, you may be able to cancel the agreement. Similarly, if the original purpose of the contract is destroyed, called frustration of purpose, Oklahoma courts may allow you to walk away without penalty. What happens if you cancel without legal justification? If you cancel a contract without cause, you may be sued for breach of contract, which can lead to court-ordered damages, legal fees, harm to your reputation or credit. Before canceling, always talk to an experienced attorney to evaluate whether you have a legal right to cancel or need to negotiate a termination agreement.